Our discussion today is focusing on the bench. We want to look at how the judiciary is progressing since independence. And who better to take us through this particular conversation than the Deputy Registrar of the Judiciary, that is Honorable Paul Ndemo, who doubles up as the judiciary spokesperson as well. Welcome, sir.
Thank you very much, Abdi.
And Mr. Paul, we can start on giving us the general outlook of how the judiciary is progressing so far. How is the judiciary faring on?
Well, let me start by saying, first of all, thank you very much for this opportunity for us to talk about the judiciary. You know that we have been on a trajectory of engaging with the public, trying to share what we are doing so that the public can get to appreciate. And I would piggyback that on the fact that the judiciary has actually been on a transformation journey. If you look at the post-2010 constitution, when we had the first Chief Justice come in, then post the promulgation, Justice Willie Mutunga, he set out on a transformation journey, which he called the Judiciary Transformation Framework. And we moved from there to Justice Maraga, talking about sustaining judiciary transformation. And now we are looking at having a social transformation through access to justice under the current Chief Justice, Justice Martha Koome.
Given that you have given us an elaborative journey all the way to have reached here in the year 2025, I'm sure you have had hiccups along the way. Let's start with this year. We have witnessed, even in terms of accountability and transparency, ensuring that the judiciary is accountable to the taxpayers down there. The first thing we've witnessed is a lot of petitions that have been brought before the Judicial Service Commission, which is now a live matter active at the High Court, in regards to the Chief Justice and the bench itself of the Supreme Court. So why are we seeing these cases here and now?
Well, specifically this particular case, as you rightly mentioned, and you appreciate the limitation that we have. The matters are live in court, and so we really can't go into the merits or otherwise of these particular cases. But then everybody has a right to go to court to enforce their rights. And so even given in the current scenario, the judges also have their right to go to court to be subjected to what they consider to be a fair process. And so the matters are in court, they're being handled there. In fact, some were just mentioned today. So the matters are ongoing, and within a short time, we'll get to see the outcome of those particular cases. But let me say that the judiciary is very open to accountability, very open to scrutiny. And so this should not be taken as a means of people fighting or the institution fighting attempts to have it scrutinized. We are subject to parliamentary oversight by the Justice and Legal Affairs Committee. We submit ourselves to the Parliamentary Accounts Committee. The Judicial Service Commission itself oversights what the judiciary does. But it is very important that we understand the importance of having an independent judiciary. And when you talk about independence, we are talking about decisional independence. And it is so critical to have that protected in any democracy to ensure that you have got a state where there is rule of law and where there is stability. If the question of the independence of the judiciary is not looked at carefully, then you jeopardize the entire state. So it is really, really important that it is safeguarded. And I have said time without number that because of the issue of decisional independence, and many people don't appreciate this, that the Chief Justice cannot pick up her phone and call a magistrate who was appointed yesterday and direct that magistrate to make a decision about a case one way or the other. Not even the Chief Justice. That is what we call decisional independence. And it runs right from the youngest, the newest magistrate, right to the top. So that is why within the Constitution, that very critical concept is protected. So if the Chief Justice internally cannot call a magistrate and tell them what to do, then it is expected in a democratic society that respects the rule of law, that seeks to ensure that we are adhering to the constitutional virtues and values, that interference really destroys that sense of independence, and it shouldn't be for the sake of the country.
Deputy Registrar, you've just brought up something that Kenyans have been talking about in terms of independency. There are talks out there that the judiciary is another appendage of another arm of the government. How true is that, and how independent are you?
It would be interesting to get something very specific, but I can tell you, the judiciary is what you'd call an umpire or a referee. Many of us watch football. The job of the judiciary is to be an independent and an impartial referee. That is what we have done. When you look at the decisions that the judiciary has meted out over the last many years, they speak of an institution that is conducting its role knowing it is standing in a place of trust where it is meant to make a decision one way or the other. So some decisions, many decisions, have been made against other arms of government. And it is not for the sake of just making those decisions, no. It is because as an independent arbiter, you are supposed to make that decision. So when the facts come before a judge or a judicial officer, that judge or judicial officer will look at what do I have and what is the law. So if the evidence and the law is against an individual, then the court will find against that individual. If the law and the facts are against a government entity or another arm of government, then it behoves the judicial officer or the judge to find against that particular entity. And we have seen the court do that in many, many instances, that I could cite here. We have cases where the courts have made decisions against the Inspector General of Police, where matters have been brought to court. And it is not personal. This is the responsibility of a referee. A referee doesn't go into a football match saying, I am going to, at the end of this game, these people must have 2 and I must get nil for this team. Whatever happens, that's not the job of a referee.
Mm-hmm. And moving forward, given that you've just elaborated to us, you can't speak about the issues that are live in court. Maybe tell us the procedures. From the High Court, where are we likely to see these cases of the Supreme Court benches, judges reaching?
There's an appeal mechanism. The matters would be heard in court, and depending on the outcome of the cases, then either of the parties could then decide to move to the next level, which would then be the Court of Appeal. And obviously in the instant case, it would also be very awkward, because after the Court of Appeal, if you wanted to then appeal beyond that, then there is no Supreme Court that would be sitting. But the next level would obviously be the Court of Appeal, should any of the parties feel that they have been aggrieved or they want to advance their legal rights.
Maybe to a Kenyan who needs to understand, let's say, for example, it passes the Court of Appeal, it comes to the Supreme Court judges, and they're the ones who are being petitioned about. So where does that case go? To the East African Court, or does it go back?
Well, your guess is as good as mine. The case is supposed to go to the Supreme Court, but you cannot be a judge in your own cause. That's a principle in law. You cannot sit and decide in your conflict of interest. You cannot be a judge in your own matter. So obviously, then that would not be an option to go there. So let me not go into the merits or otherwise, but that would be a conundrum.
Okay. And progressing on well, the judiciary has been combating a vice known as corruption for years on end. We've seen the systems that the judiciary has put over the years, especially in coming up with digitalization of some of the court proceedings, on how you receive your funds as well, and some of the fines that are being paid. Maybe we'll start on that. The Ethics and Anti-Corruption Commission just handed over a report to the CJ just a few weeks back, detailing where the issues are and how you can resolve them. Maybe bring us up to speed. What were some of those issues that were raised in that particular report, and as a judiciary, how have you addressed them?
Thank you for that question. First of all, it's good to clarify that it is the Honorable Chief Justice herself, when she came to office in 2021, who invited the Ethics and Anti-Corruption Commission to come and do what we call a systems review. So just come and look at the systems that we have as the judiciary to be able to help us appreciate where do we have vulnerabilities that are susceptible to corruption so that we can improve, because EACC have got that capacity. That is one of their mandates. So invite the experts to come and tell you, I think I am doing okay, but there may be one or two areas that I need to work on. So the Chief Justice invited EACC. They came and we opened the whole place to them and told them, please, look, we've invited you, just go around and see. So they went and looked at some of our processes in the registries where cases are filed. They went and looked at some of the regulations that are there in the procurements of like the building services that we have, and some of the policies that we also have. And so in their recommendations, we needed to tighten some of the processes within the registry. Others, they recommended automation of services. Happily, there are things that we were already doing. It is not as though we were doing nothing when they came. There's a lot of things that were happening. So as they also gave their recommendations, those recommendations found us quite advanced in some of the areas we had started. So for example, the development of policies, the development of manuals. How do you handle cases in the registry? How do you deal with, just different aspects of the law? When people come to the registry, when people come to court, how do you handle those particular matters?
Mm-hmm. And of course, you've brought up something very important. Even the Chief Justice a few weeks back spoke about it once she received the report from the Ethics and Anti-Corruption Commission. In terms of, are there brokers in the judiciary, or is it the judges or the magistrates themselves who are those conduits who are either abetting or abetting corruption? So to that effect, are judges and magistrates susceptible to corruption? Because that is what Kenyans are asking.
That's a very interesting question. I think everybody is susceptible. Let me say that. But most of our judges and judicial officers, people are very serious about the work they do. The level of commitment, the dedication that we have, the oath that we have sworn is a very serious oath. And so by far the vast majority, are very dedicated and very committed to their oath. And so from that point, and actually from even the cases that are handled, you can tell, short of what I'm telling you about perception, there is a lot that is put in there to ensure that everything just, proceeds as is the case. But when you then have persons that you can't tell, are these judiciary staff, are these employees here, are these not, you tend to get mixed up. In that melee, you tend to get mixed up and people say, this is the judiciary. So I want to assure you that the judiciary is a very committed institution to issues of integrity. And it is very, very easy. If you have a judge or a judicial officer who is oriented in that direction, it will not take long before they're discovered. So for you to be in an institution where we have been serving justice for this long, and you have got, few cases, sprinklings here and there, then you can tell the dedication is there. But as I said, there are also things we are doing to ensure that we keep that high standard, because we are independent arbiters. We are supposed to be blind to any side. Let the case come before you. Decide it as a judge or a judicial officer in the best way that you understand, according to the law and according to facts.
Deputy Registrar, the reason why I was asking you that particular question, we have seen the product, some will say, of the investigations, or rather, given that you had invited EACC here, they had singled out various courts, which even the Chief Justice herself admitted that there was several courts that were aiding and abetting corruption. And we witnessed what happened just the other day about the Thika magistrate that was apprehended by the Ethics and Anti-Corruption Commission. We saw saw the judiciary coming in the retrospect of many people assuming now, given that one person from the judiciary, either magistrate or a judge, has been apprehended by another investigative body, they can be protected by the institution called the judiciary. Is that the case?
So first, let me just clarify that the courts where EACC is investigating, those cases are places where we ourselves got intelligence and we shared that with EACC. It is not places where EACC went and found that. We ourselves, because we also get intelligence from the ground, from our customers, our stakeholders, so we get to know. And where you know that there seems to be an issue in this station or the other, then because the arm that has got that, or the entity that has got that mandate and the capacity to be able to properly investigate and deal with the matter is EACC. So that is how we then, the Chief Justice said, we are working with EACC. And it is then to those, some of those stations where we said, check here and here and here and here. And that is, so EACC will handle that matter, have it taken to the DPP, decide on whether it meets the threshold, and then the matter will be taken to court. The court will not protect its own people. No. What is there is that there's process. And everybody has got a right to a fair process. And so if an individual feels like there's something that is not right, this process was not properly conducted, then every single individual, an ordinary citizen, a public servant, a judicial officer, whoever you are, you've got a right to approach the court so that you can enforce the rights that are given to you in the Constitution. Being a judicial officer or a judge does not take rights away from you to say that because you are this now, you have got no avenue. If I feel aggrieved as an individual, whoever you are, you've got that access, and it's been given by the Constitution. In fact, Article 48 is very specific that the state should grant access to justice for all, everybody. It doesn't matter who you are. So the fact that someone goes to court does not then remove from the fact that, you know, that avenue is not available to them because of the position they hold.
And of course, given that you've also revealed to us that you're receiving intelligence reports on how the courts are progressing and how Kenyans are being dealt with, because you see, those are issues that Kenyans themselves were able to raise. Maybe give the public confidence on how you address them in those courts places where you clearly stated that those issues were being recorded. How did the judiciary deal with the officers, either even if it was the judge, if it was the magistrate, or even the judicial officers around that particular precincts? So how did you deal with it?
So first of all, we have what we call the court users committees. These court users committees are committees that are formed at the level of the courts. And within those courts, we have got different players, what you'd call our stakeholders in the justice sector. So you'd have the prisons, you'd have the office of the DPP, you'd have the probation, you'd have law society and others. So a number of issues are actually many issues are actually dealt with at that local level. But then where sometimes matters, you may find maybe some matters are not clear. You hear this, you hear that, you are not very clear. It is where now we find we need to have an entity that really has the capacity, because each of these people have got a different mandate. They will not go and start investigating. So when we get feedback, maybe I should have called it feedback, not intelligence, but it's really the same thing. That's when now we have EACC, we are hearing things from some of our stakeholders in this particular situation. Could you go and just confirm that? And if it's a matter that requires EACC's intervention, then they will process it and they will deal with it. But there may be other smaller issues, infractions that we can handle, misconducts of a lower level. And those ones, we deal with them quite periodically, not necessarily related to corruption.
So you're telling Kenyans you have addressed those issues at those courts that were singled out by the CJ?
They are still being addressed. Yeah, some have been addressed, others are being addressed. Because, you know, investigation is also, is not a one-day thing. It's a process. It takes time for you to, you know, collect the evidence, for the investigators to establish what has been said here, get interviews, record statements. So that is a process that is ongoing in a number of those stations.
Now, moving back to our earlier conversation in terms of digitalization, which the judiciary has done over the years. Earlier on, just 3 months ago, we heard from one of your Supreme Court judges, that is Isaac Lenaola. He talked about an instance where we witnessed where the e-filing system of the judiciary went down. So how many times do you see these issues? What was the glitch? Because the judiciary, when it spoke back then, 3 months ago, he told us he will give us an extensive update on what exactly happened that particular day. So do you experience this normally, and how is it addressed?
So sometimes we have the normal downtimes, you know, for the internet provision. There may be something that is happening across in the system. So that may happen once in a while. But we don't have it's not a very common feature to have, you know, like the system down. We have really tried to protect our systems and to boost them so that we ensure that this is seamless. I mean, remember, we are having e-filing across the whole country. So this is a very, very big deal for us to ensure that our systems are protected, and we are working with the relevant agencies with the data and with the systems that we are operating.
With that in mind, Deputy Registrar, the reason why I was asking that, do you run your own system or is it run by another government institution?
Well, all government agencies have their systems run through government. So we are also subjected to, you know, another government agency that really runs the system.
Have there been attempts to hack your systems, and how has that affected your systems?
Well, I wouldn't say whether it is an attempt to hack or not, but when we've had some incidents, we have actually, in one particular case, we wrote to the Communication Authority just to, you know, help us establish what exactly could have happened at that particular time. But as I said, it is a very rare occurrence in our systems.
And we've seen a keen relationship between the bench and some of the lawyers in the country. We've witnessed how sometimes it can be cordial, sometimes it cannot be cordial. The reason why I'm asking you this question is we have witnessed a ruling that was made, or a judgment for that matter, here at the Supreme Court, where the judges clearly stated that two lawyers, that is Nelson Harvey and Ahmed Nasir, cannot come there. If their clients are coming to the Supreme Court, they should be seeking the interventions of other lawyers. So maybe you can tell other lawyers who are out there and Kenyans alike who want to seek services from the legal counsel. What laws were premised on this judgment, and in the future, how can it be made better?
Abdi would know that matter is live right now, not only here in Kenya, but you know, even in the East African Court. So it's a matter that is still being prosecuted, and I would ask that I don't delve into the matter now.
Okay, thank you for that. And also, moving on swiftly, you know, everybody is going to Parliament asking for their funds to fund the operations that we'll be using in the financial year. Maybe, given that in the judiciary we have witnessed so many instances where the current CJ as well as the former CJ have been clearly stating that they are underfunded, they require more funds for critical services for Kenyans alike. So how much money, for that matter, are you looking for, if you have just a rough idea, and which areas are we likely to see those funds being channeled to?
So we're seeking about 50 billion for the next financial year. The indication of what we have gotten is 26 billion. Initially it was actually 25, and then after some discussion it was enhanced to 26 billion, so by $1 billion. Now, it's important to just contextualize the issue of funding for the judiciary. The judiciary has had a historic underfunding challenge. If you look at, for instance, the courts that we have, most of the courts that we have, we inherited from our colonial masters. most of them. The new courts that were built in the last, I would say, about 10 years, are courts that we got funding from the World Bank. These are courts that were done in, across the country in a number of places. When you look at the numbers I told you at the beginning, we had just about 47 judges and maybe 300 or 400, actually I think 300 magistrates, 400 magistrates at the promulgation of the Constitution. We are now 50 million. Our economy now is in the trillions. The funding has not moved together with the growth of the economy.
We've just talked about the working conditions of judges, magistrates, and the judicial officers who are within various parts of the country. The other concern that we have even witnessed judges and magistrates raising is their safety. We have not witnessed once or twice, even the Chief Justice herself, where security is withdrawn. Do you get adequate answers from the National Police Service, who are just your neighbors here? Do you get adequate answers on why the security of judges are withdrawn anyhowly? Do you receive substantive answers from the National Police Service?
Well, since the last incident that happened to the Chief Justice, we've had some engagements with the police, and I would say at the moment we are fine, and we hope that obviously that relationship continues, because it's very important that judges, judicial officers feel safe. We have been exposed to very serious incidents of insecurity from Makadara last year, very, very unfortunate. And that has really put to the test the resilience and just the commitment of judicial officers. When people have to go to work every day knowing that I am coming to serve and I might lose my life just simply because I've come to work, that's outrageous. It shouldn't be. It shouldn't be. And so we are very hopeful that with the discussions we've had, with the commitment that was given by the Cabinet Secretary for Interior, that matter really it should never recur again, not in a society like ours.
Mm-hmm. And maybe in your final remarks, we have seen the judiciary banking on public engagements. We have seen even judges of the Supreme Court going to give lessons to schools out there in the public, and trainings being conducted. So what can we look forward to that aspect?
Yeah, we are very open. We are very open. I think we, for a long time, took the traditional approach that we speak through our pens as judges and judicial officers. But we've also realized that there's a lot of misunderstanding, misinformation, disinformation, And so we felt it's very important that we go to the ground. Let's interact with the people, because we have nothing to hide. It's just the way the structures were previously. The legal profession for a long time has been a very conservative. We sit here, we do our work, we expect people to understand, but we realize that it's important for people to get to know what is it that we are doing as the judiciary, how are cases filed in court, who is responsible for what, who does what.
The judiciary has opened its doors. You want to bring your petition, you want to bring your case. If you want to hear any concerns that you may have with either of the judges, or what you'd like to give us pointers on how the judiciary can better services to you as Kenyans, there you have it. They have an open door policy at the end of the day. The trainings and dialogues and lessons will be carried across the country. That concludes our conversation with the Deputy Registrar of the Judiciary, that is Mr. Paul Demo, who also doubles up as the judiciary spokesperson. For now, my name is Abdiaziz Hashim. Back to you in studio.